when the feds quash free speech with legal tyranny. 25 June 2015. Imagine you run a website and are ordered by the federal government to divulge personal information on article commenters. Now imagine that the feds also issue a gag order preventing you from revealing what they're up to. This is precisely what happened with award-winning libertarian website Reason.com. Site editor Nick Gillespie related his travails just today at the Daily Beast, and it is a story many will find chilling. His problems began after he blogged about the life sentence handed down to Ross Ulbricht, founder of dark web website Silk Road, by a judge named Catherine Forrest. Not surprisingly, agitated Ulbricht defenders took to his piece's comments section and par for the internet course, savaged Forrest. As Gillespie writes, they suggested that, among other things, she should burn in hell, be taken out back and shot, and, in a well-worn internet homage to the Coen brothers' movie Fargo, be fed feet first into a wood chipper. The comments betrayed a naive belief in an afterlife. Note, my libertarian friend Gillespie, that people without that naive belief in an afterlife generally have a naive belief in government and karma, were grammatically and spelling challenged, hyperbolic, and completely within the realm of acceptable internet discourse, especially for an unmoderated comments section. Gillespie then continued, but the U.S. Attorney for U.S. District Court for the Southern District of New York thought differently and on June 2 issued a grand jury subpoena to Reason for all identifying information we had on the offending commenters, things such as IP addresses, names, emails, and other information. At first, the feds requested that we voluntarily refrain from disclosing the subpoena to anybody. Out of a sense of fairness and principle, we notified the targeted commenters, who could have moved to quash the subpoena. Then came the gag order on June 4, barring us from talking about the whole business with anyone outside our organization besides our lawyers. To top it off, this gag order even prohibited Reason from mentioning the gag order. As Gillespie put it, you can't even respond honestly when someone asks, "Are you under a court order not to speak?" It cannot be overemphasized that the comments in question were not true threats, but simply the kind of blowing off of steam that occurs millions of times weekly on the internet. In other words, the Fed's action was an outrageous abuse of power, something any of us could be subject to dare we utter words which our government overlords don't approve of. This, by the way, is the opinion of legal blogger Ken White of Popeha, to himself as a former federal prosecutor. Before relating his commentary, let us be clear on how this can touch any of us. Imagine you publish an article the state dislikes, which Gillespie seems to imply was the case with the Ulbricht piece. All government attorneys need do is take a gander at its comments section, find the ever-present hyperbolic posts, and under the pretense that they were threats issue a subpoena against you. Then, as Gillespie writes, you are forced, at serious financial cost and disruption of your business, to dance to a tune called by the long arm of the law. The result? Maybe you stop covering those issues the government finds sensitive. Or perhaps you eliminate your comments section, in which case the average citizen loses his voice. And maybe that average citizen even ends up spending months in jail and facing 8 years in prison, which is the plight of a teenager I wrote about here. In other words, the government is saying, yeah, you have freedom of speech *wink*, nod*, and you can exercise it in a way we don't like. But it will cost you. Free speech isn't free when you have to pay for it. This technique of using judicial persecution where goals cannot be accomplished legislatively is nothing new for the left. Just consider how, unable to pass further gun control laws, governments then filed lawsuits against firearms manufacturers, or how the Boy Scouts were sued years ago by atheists, homosexuals, and a girl who wanted to be a Boy Scout. Some may say this is the plaintiff's right, as everyone deserves his day in court, but it takes on a different flavor when the goal isn't winning but destroying. Presenting organizations with the prospect of years of bankrupting legal fees is an act of compulsion that modifies behavior. As Mark Stein has noted, the process is the punishment. Now let us return to former federal prosecutor Ken White, who elaborated on the government abuse of power. First, the subpoena. Some have argued that the Department of Justice must have had information spurring them to use the grand jury to pierce the anonymity of people engaged in protected political speech. Not so. As Reason's report shows, Assistant U.S. Attorney Nick Fellamore never articulated any specific basis to fear the bluster of these commenters any more than he did when I spoke to him. Saturday I interviewed Mike Gillespie, publisher of Reason, who confirmed that Fellamore never suggested that he had any basis to view these as true threats. In fact, he seemed uninterested in the distinction between protected speech and true threats and refused to narrow the subpoena to carve out the patently non-threatening, special place in hell, commenter. There's no secret ticking time bomb, no wizard with a wood chipper, no classified justification. This was the Department of Justice targeting speech because it could. This is no rash accusation. 3 of the offending internet commenters had links back to their personal web pages and a couple of others could be found via a few minutes on Google. Why subpoena someone for public domain information? Maybe because obtaining the information isn't the true goal. White provides many more details than I can relate here, so I suggest you read his whole piece. Among other things, however, he points out that United States Magistrate Judge Frank Moss issued the gag order without due justification, as he apparently just took the government's word for it, because of course, the government never misleads federal judges, writes White. White also mentions that Moss is a colleague of Judge Forrest, the jurist the hoi polloi had the temerity to criticize. In fact, the two work in the same courthouse. White further states that while Fellamore violated a legal rule, details at White's site, he won't be disciplined because courts have decided that it would be too burdensome to require federal prosecutors to abide by local ethical rules, rules that apply to literally every other lawyer in the United States. As a result, Nick Fellamore gets away with being, as White puts it, a goon hiding behind a badge. Also know that the only reason Reason is talking now is because the gag order has been lifted. But this is, Mark Stein writes, not because this goon Fellamore has decided to straighten up and fly right, but because once Pope had uncovered the story and others picked it up there was no longer any secrecy to protect. And that is the bottom line. The government wanted its abuse of power kept secret. And you on this, wrote Gillespie, there is every reason to believe that various publications, social media sites and other platforms are getting tens of thousands of similar requests a year. How many of those requests are simply fulfilled without anyone knowing anything about them? And how much valid information may we be denied because of the state's end run around the First Amendment? The government as legal army, funded with our tax money, can be a perpetual motion machine of pain and persecution. Its actions induced in Reason's staff anxiety and fear. Moreover, had Fellamore chosen to push his power play, wrote White, he could have bankrupted Reason. And we have every reason to expect there will be more victims as our country and its government become more morally bankrupt all the time.